If you have been seeing headlines like "No more U.S. citizenship," or "They can revoke your citizenship under a new 10-year rule," take a breath. This is one of those topics that spreads fast because it hits a real fear. You did everything right, you became a citizen, and then you worry it can all be taken away. Here is what matters today: what is actually being proposed, what the law already allows, and what practical steps you can take right now to protect yourself and your family. By the end of this video, you will know 3 things. First, what denaturalization really is and what the government must prove. Second, who this proposal would target versus who is likely not affected. And third, a simple do this and avoid this checklist so you do not accidentally create problems in records, travel, or future applications. Now, what changed? Based on the brief we have, a Missouri Senator, Eric Schmitt, introduced a proposed bill described as the Stop Citizenship Abuse and Misrepresentation Act, also being called the Scam Act. The way it is being discussed is that it would expand the government's power to pursue denaturalization against naturalized Americans involved in certain serious crimes like felony fraud, espionage, or being linked to a foreign terrorist organization. And the headline-making piece is a proposed 10-year window after you naturalize. The idea, as described, is that if a naturalized citizen commits a serious crime during that 10-year period, that later crime could be treated as strong evidence that the person lied during the citizenship process, which could then be used to seek denaturalization and, potentially, removal from the United States. Here is the part most people miss. A proposed bill is not the same as a new law. A lot of viral posts talk as if USCIS has already changed the rules, or as if citizenship can be revoked automatically. That is not how it works. Denaturalization is real, but it is not a quick administrative switch where someone at USCIS pushes a button and your citizenship disappears. It is typically a serious legal process with a high burden and specific legal theories, usually centered on fraud or willful misrepresentation during the naturalization process, or certain categories tied to unlawful procurement. So let us slow down and define the key term in plain English. Denaturalization means the government takes someone who became a U.S. citizen through naturalization and seeks to revoke that naturalization, turning the person back into a non-citizen. If that happens, then the person's underlying immigration status matters a lot, because if they do not have a valid status to fall back on, removal proceedings could follow. That is why this topic feels so high stakes. Now, what is the proposal actually doing, based on the description we have? The brief says it would expand the government's power of denaturalization, and it emphasizes a 10-year window after naturalization. The way it is framed is that certain serious crimes committed in that window could serve as strong evidence of lying during the citizenship application process. But you should separate 2 ideas that people often blend together online. Idea 1, can a naturalized citizen lose citizenship? Yes, in limited circumstances, typically involving fraud or material misrepresentation or other narrow grounds defined by law. Idea 2. Can the government take away citizenship just because you later committed a crime? Generally, not automatically. Later crimes can trigger criminal penalties, immigration consequences for non-citizens, and sometimes they can become evidence in a denaturalization case if the government argues the crime reveals you lied earlier. That distinction matters. This is where people get denied or panic unnecessarily. They assume any criminal issue after naturalization equals instant loss of citizenship. That is not what the current system is supposed to be. Let us talk about who is affected versus who is not, because this is the most practical part. If you are not a naturalized citizen, for example, you are a green card holder, a student, a worker on a visa, or you are undocumented, this particular denaturalization discussion is not directly about you. However, it still matters because it affects how people think about applying for citizenship and how carefully you should document your eligibility and disclosures. If you are a naturalized U.S. citizen, you are the group that denaturalization laws technically apply to. But within that group, risk is not equal. Most naturalized citizens will never face denaturalization because the government typically targets cases where they believe there was fraud, a serious misrepresentation, or disqualifying conduct that should have prevented naturalization. If you naturalized long ago and your application was clean, your risk is generally low. If you naturalized recently and there are unresolved issues like prior immigration violations, unresolved criminal matters, or questionable documents that were used in the process, the risk can be higher. Not because you are automatically in trouble, but because those are the types of facts the government might later examine if something else triggers scrutiny. Now, here is an edge case that causes confusion. What if you made an honest mistake on your N-400 or in an interview? Mistakes happen. Denaturalization is usually not about innocent typos. The legal concept people should understand is material misrepresentation and intent. Material means the truth would have mattered to eligibility. Intent means it was not just an accident. That is why, in practice, denaturalization cases tend to focus on serious, provable issues. Microhook. Two groups are at the highest risk in any denaturalization framework. Group 1 is people who actually used fraud or fake documents to obtain a green card or citizenship. Group 2 is people who had disqualifying conduct like certain criminal history or immigration violations and deliberately hid it. Now let us unpack the so-called 10-year rule because that is the line everyone is quoting. Based on your brief, the bill would create or expand a framework where serious crimes committed within 10 years of naturalization can be treated as strong evidence that the person lied during the citizenship process. Notice the wording, evidence of lying during the citizenship process, not simply punishment for the later crime. What does that mean in practice? It sounds like the proposal is trying to make a legal inference easier. If you become a citizen and within 10 years you commit a serious offense like felony fraud, espionage, or conduct linked to a foreign terrorist organization, the government could argue this suggests you were not truthful or were not eligible at the time you naturalized, or that you misrepresented facts. The bill, as described, appears to be designed to strengthen the government's ability to bring those cases. Here is the small detail that changes everything. Evidence is not the same as proof. Even if a later crime is used as evidence, there still has to be a legal case that connects the dots back to the naturalization process. The government would still need to argue and prove the elements required under the law to revoke naturalization. Myth versus reality. Number 1. Myth. They can revoke your citizenship for any crime within 10 years. Reality. Under the description provided, the theory is that certain serious crimes within that window could be used as evidence of earlier fraud or misrepresentation. It is not an automatic switch for any offense. Myth versus reality. Number 2. Myth. This means citizenship is now temporary for 10 years. Reality. The proposal does not sound like a temporary citizenship system. It sounds like a proposed evidentiary or enforcement expansion focused on denaturalization cases tied to fraud and serious conduct. Now, why is this happening? The brief mentions a Minnesota welfare fraud case that spurred the bill, and it also mentions White House support. I cannot verify those details beyond what you provided, so treat them as context being reported, not as confirmed fact in this script. But as a general policy dynamic, highly publicized fraud cases often lead to proposals that aim to expand enforcement tools, especially when lawmakers argue that existing law is not enough or is too hard to use. Also, timing matters. Immigration agencies and the Department of Justice operate under resource constraints and shifting priorities. When there is political attention on fraud, national security, or public benefits abuse, we often see proposals or policy discussions about stronger screening, tighter interpretation of misrepresentation, and more aggressive post-naturalization review. Here is another part most people miss. Denaturalization is not just about immigration. It intersects with criminal law, national security, public benefits compliance, and document integrity. That is why proposals like this tend to list categories like felony fraud, espionage, and terrorist organization links. So, what are the real-world consequences if this proposal becomes law, or even if it does not become law but increases public attention? First, fear and confusion can cause people to make bad decisions. People stop traveling, stop applying for citizenship, or avoid renewing a passport out of panic. You do not want to do that. Second, it can increase scrutiny in certain types of cases. If you have a complicated history and you are in a situation where the government is already reviewing your records for another reason, heightened attention on denaturalization can make officers and attorneys more likely to recheck older files. Third, it can impact families because one person's case can ripple. For example, if someone's citizenship is questioned, it can complicate petitions they filed for relatives. This is not to say it automatically cancels family cases, but it can create delays and requests for evidence. Fourth, travel and identity documents. If you are a U.S. citizen, you travel on a U.S. passport. If a denaturalization case is initiated, it can create uncertainty and, in some situations, lead to complications in renewing documents or dealing with agencies. Again, not automatic, but it is a stress point. Now let me give you two example scenarios. These are simplified composites, not a claim about any real person. Example Scenario 1. A naturalized citizen becomes a citizen and then, 5 years later, is charged and convicted for a serious fraud scheme. During the criminal investigation, evidence emerges that the person used false identities and false documents years earlier to obtain lawful status. In a situation like that, the later fraud is not just a later crime. It becomes a spotlight that uncovers earlier misrepresentations. A government attorney might argue the person never lawfully qualified for naturalization because the underlying status was obtained by fraud. That is the kind of pathway where denaturalization becomes plausible. Example Scenario 2. A naturalized citizen makes a mistake on the N400 years ago, like forgetting an old address or misremembering a travel date by a few days. Years later, the person gets a traffic-related misdemeanor. Viral posts claim any crime within 10 years means citizenship is gone. In reality, that later minor offense would not magically prove the person lied during naturalization. Mistakes that are not material and not intentional typically do not fit the classic denaturalization theory. Here is the bridge hook. If you only remember one thing, remember this. Denaturalization cases generally rise or fall on whether the government can show your citizenship was obtained unlawfully, usually through material misrepresentation or concealment, not on the mere existence of a later conviction. Now, let us get practical. What should you do now, while this is a proposal and not necessarily law, and while the news cycle is hot? Do this. Save your immigration record set. Keep a secure folder with your green card application copies, your N400 copy, your naturalization certificate information, interview notices, and any supporting documents you submitted. If you used an attorney, request a full copy of your file. Do this. Check consistency across records. If you have ever filed multiple forms over the years, small inconsistencies can create questions. You are not trying to rewrite history. You are trying to understand what is on paper. If you notice a serious discrepancy, do not guess your way through it. Get qualified help. Do this. Keep certified court dispositions for any arrest or charge, even if it was dismissed. A lot of people cannot prove what happened years later, and that causes problems in background checks or future applications. Do this. Be careful with travel if you have any ongoing criminal matter. This is general safety planning, not legal advice. Travel while a case is pending can create missed court dates, warrants, or confusion at the border. If you are a U.S. citizen, you generally have the right to enter, but you do not want to create avoidable complications. Do this. Monitor official sources for updates. If a bill is proposed, you can watch for updates through official congressional tracking tools and reputable immigration organizations. Also watch USCIS and DOJ announcements for any general policy updates, if they occur. Avoid this. Do not rely on viral clips that say everyone will lose citizenship after 10 years. That framing is designed to trigger panic. Avoid this. Do not post details of your case on social media asking strangers for advice. Keep sensitive facts private. Avoid this. Do not sign or file anything new with inconsistent information just to match something you now think is wrong. If you need to correct something, do it the right way with guidance. Avoid this. Do not assume that hiring a notario or unlicensed preparer is cheaper and safer. In denaturalization conversations, the consequences are too serious to gamble on bad preparation. Myth versus reality number 3. Myth: USCIS can denaturalize you by itself during a routine appointment. Reality: denaturalization is typically pursued through a legal process, often involving federal court, and is not the same as USCIS denying a routine benefit. The process is serious and not casual. Now, what could happen next with this proposal? Watch point 1. Whether the bill actually moves forward. Many introduced bills never become law. The outcome depends on committee action, votes, and the broader political environment. Watch point 2. Whether any agency issues guidance or priorities that increase denaturalization efforts even without new law. Sometimes enforcement focus changes through internal prioritization, but do not assume that happened unless you can see official statements. Watch point 3. How the 10-year concept is written, if it advances. There is a big difference between a rule that creates a presumption, a rule that changes burdens of proof, and a rule that simply directs resources. The details determine the real-world effect. Watch point 4. Court challenges and constitutional questions. Any policy that affects citizenship can face significant legal scrutiny. Again, we cannot predict outcomes, but it is something to watch. Here is a quick if you are in X group, do Y segment. If you naturalized within the last 10 years, be extra organized. Keep your full records, keep court dispositions if any incident ever happened, and do not ignore any official mail from a court or federal agency. If you are applying for citizenship now, focus on accuracy. Disclose what must be disclosed. Do not minimize, do not guess, and do not let anyone convince you to hide facts. If something is complicated, get a proper legal consult. If you are a long-time naturalized citizen, do not panic. But still keep your documents safe, because replacement paperwork can be harder years later. Now let us tie this back to the claim about deportation and loss of citizenship. If someone is denaturalized, they revert to whatever status they would have had without the naturalization. In many denaturalization theories, the government argues the person never lawfully obtained status in the first place, which can then open the door to removal. But remember, that is after a legal process, not an automatic consequence of an online headline. One more bridge hook. This is where people accidentally self-sabotage. They hear a rumor, then they stop renewing a passport, stop responding to mail, or move without updating addresses. Those choices create real problems. Staying organized and responsive is the safest move. Let us do a calm recap. Number 1. What you are hearing about is a proposed bill, not necessarily a new rule in effect today. Number 2. Denaturalization is real. but generally requires a serious legal case, often focused on fraud or material misrepresentation during the naturalization process. Number 3. The proposed 10-year window, as described, is about using certain serious crimes as evidence of earlier lying, not about making citizenship temporary. Number 4. The people most at risk are those with provable fraud, concealed disqualifying conduct, or serious facts that connect back to eligibility. Number 5. Your best protection is boring but powerful. Keep your records, keep certified dispositions, be accurate on forms, and follow official updates. If you want, comment with your situation in general terms, like naturalized in 2018 and applying for a passport renewal, or green card holder considering N400, and I will cover the most common next steps and official resources to check. And if you want clear updates like this without panic, subscribe and turn on notifications, because these immigration headlines move fast, and the details are what keep families safe.